Pleasure.
Yes.
Lordship, I beg to mention for listing a WPC matter relating to regularization of service, Lordship. Any date, Lordship, convenient?
Yes, after Bihu vacation. Yes. Next matter.
My lord, this is a very urgent matter, my lord.
Hmm.
This is supposed to be listed today.
What is
Even
the
I-
urgency?
My lord, this is the doctor has been removed from the register of medical science, my lord. And there is the order of this honorable court also for listing the matter, but it is not listed today, my lord.
Mhm.
So it may come up tomorrow, my lord.
All right.
May I please, your Lordship?
Yes, yes. One of you can go. Yes.
May I please, your Lordship? Lordship, item number 48 and 49,
Hmm.
kindly adjourn to this proceeding and fix the matter after Bihu.
48, 49, you are for the petitioner.
I'm for the petitioner in 48 and 49. And one more humble submission before Lordship.
Hmm.
In the cause list today, in item number 48,
48, 49 on the request of learned counsel for the petitioner matter stands adjourned for 3 weeks. List after the upcoming Bihu holidays. Yes.
in item number 48, my lord,
Hmm.
in the cause list, my name has not been reflected. In lieu of which, that is some Gagan Chandra Bodua has been reflected, who is not engaged advocate in this case. So concerned authority may kindly be directed to reflect my name in place of.
By reflecting the name of Mr. J.P. Das, learned counsel in the cause list. Yes.
May I
Highly
please-
obliged, Lordship, highly obliged.
With the consent of others, sir, I beg to mention item number 22. Here, Lordship, I have to file my affidavit. I request some time. I have taken the consent, Lordship.
22. On the request of Mr. S.S. Roy, learned CVC made with the consent of the other side. This matter stands adjourned for 2 weeks so as to enable him to file affidavit.
Obliged.
Please, Your Lordship.
Please
I
take
beg to
up-
mention item number 24, my lord. On
Item
behalf of
number?
item number 24,
Yes.
on behalf of VK Raj, he is on medical leave, my lord. Kindly adjourn the
On the
matter.
prayer of learned counsel for the petitioner,
It's taken on after Bihu, my lord.
this matter stands adjourned for 3 weeks, list after the upcoming Bihu vacation.
Lordship, it was not item 20, it was item 34, Lordship.
Item 34,
I'm the
Lordship.
petitioner here, my lord. I'm the petitioner.
not 22, 34.
Obliged.
May I please, I beg to mention item number 4, my lord.
Yes.
So matter may be withdrawn, I may be allowed to withdraw the petition, my lord, with the liberty. Kindly please.
Why you want to withdraw?
Party, some instruction is necessary to include in the petition, my lord.
Mr. A.N. Ahmed, learned counsel for the writ petition submits that there are some shortcomings in the writ petition which calls for rectification. Therefore, under instructions from his clients, his writ petition, he seeks withdrawal of the writ petition with liberty to file afresh. Since the prayer is not opposed, same stands allowed. Writ petition stands disposed of on withdrawal with liberty as prayed for. Yes.
May I please, your Lordship? Lordship, I'm back to mention for listing of a service matter.
After Bihu.
Obliged.
I'm praying for listing a matter in the admission column.
After Bihu.
Before Bihu in the first week.
No. After Bihu.
May I please, Your Lordship, my lord, item number 28 to 31, my lord. These four matters may kindly be adjourned for 3 weeks, my lord.
28 to?
31, my lord.
Yes. What do you want?
Adjournment for 2 weeks, my lord.
Why?
My lord, whether a cause of action survives or not, my lord, I have to take instruction, my lord. Perhaps-
Oh, 28 to 31, Mr. H. M. R. Chaudhary, learned counsel, appearing for the writ petitioners in this batch of writ petitions submits that updated instructions are called for so as to ascertain as to whether any live cause of action survives in these writ petitions. On such ground, 4 weeks' time has been sought by the petitioner's counsel. Prayer is allowed. Let the matters be listed accordingly. Yes.
May I please, Lordship? Lordship, I beg to mention for listing of contempt case, Lordship.
Listing of
Contempt case, Lordship, contempt petition.
which contempt case? Why?
Oh,
You make an application before the register.
May I please, Your Lordship? May I beg to mention item number 25, Your Lordship?
Item number 25.
Lord,
Yes.
I will be allowed to withdraw this petition as the matter has become infructuous, Your Lordship.
All right, Mr. U.K. Decker, learned counsel for the writ petitioner submits that why it has become infructuous?
Already the payment has been made, Your Lordship.
That during the pendency of this writ petition, the grievance of the petitioner has been redressed and the payment has been made. As such, the writ petition has become infructuous. Taking note of the submission of Mr. Decker, this writ petition stands closed.
Obliged.
Yes.
Lordship, I beg to mention item 11, 12, and 14.
Yes.
Because of some personal difficulties, senior counsel couldn't come. Lordship, kindly keep this matter on 7th April.
I was hoping after Bihu, as Lordship has been saying.
It's
Lordship.
I was hearing consistently after Bihu. So
What are these matters?
these are APSC Lordship. Now they will all
APSC
get
sus-
contested. So
Suspend.
Lordship, I'll just assist Lordship a minute, not as a submission. Basically, there are a whole separate batch of matters that have come challenging the OMC report, one-man commission report, Lordship, and challenging a suspension order. These basically started somewhere in July last year. Different departments, they're almost about now 35 petitions. By December, January, Lordship, 2 orders get passed in a petition of the finance department, wherein A, there is a stay of the suspension, and B, a reinstatement is ordered. I'm now told there is also a contempt proceeding that has emanated for non-compliance. In the meantime, state has re-engaged me onto the matters, and we have filed vacation of those orders, Lordship, and we are filing replies in all matters. So this is also 3 of those people who have now filed fresh petitions. So they have filed earlier petitions. 2 are from Home Department, 1 is Skill Development, if I recall. So essentially, Lordship, now these will, according to me, respectfully, will have a cascading effect in terms of what is the outcome of the vacation of stay applications. Because everyone is now relying on the order of reinstatement passed in 2 and others subsequently. So this will require consideration. So in the meantime, in any case, we will end up filing replies and all that. And I would, of course, argue on that day also that vacation of stay, whenever it's listed.
So these matters are for admission.
No, my lord, it's a
Yes,
fresh
fresh.
matter, motion matter.
Okay.
Take it on 7th April is better.
I would be online. I won't be able to come physically, but if Lordship is pleased to keep it a little later also, 17th, I will physically come because I always feel it's
17th April.
good.
it's,
Then Lordship, it can be 24th.
We'll have it on 22nd.
I'm in Nagpur. So Nagpur here, there is no connect. I've checked it. 24th, I'll fly to Delhi and come back, Lordship.
You need a private jet, Mr. Patel.
Not yet, Lordship. Honestly, not
That's the issue to be argued first.
yet. Lordship, I hope it'll take me more time for that. The commercial flights are safer.
Okay.
If 24th, Lordship would be so great.
Yes.
Lordship, we have urgency. This,
All right.
Because
So
of-
motion matter.
Yes, Lordship,
We'll
on
have it on
7th.
then 11th. Are you available 11th April?
No, then 7th, Lordship. I'll try to appear physically or VC. 7th, then they are saying 7th. I'm actually, Lordship, traveling that entire period.
No, but these are things you have to sort it out. amongst
That's
you.
why I was requesting. साथ को कर लेंगे, online कर लेंगे, Lordship.
Provided it is permitted by the court.
I will graciously request Lordship to permit me to appear online.
No, how do you know where the matter will be listed?
yes.
That is a
Any
fair point.
information on that? You can share.
If I had that information, Lordship, I wouldn't need to argue. So I bow to all it. Today is one of those days, Lordship. I would say I'm clean bowled on bowl after bowl on the nets.
You are very good at your work. Let's see what happens. Yes, 7th April.
Yes, Lordship.
On the request of Ms. B. Chaudhary, learned counsel appearing for the writ petitioner in these petitions made with the consent of Mr. N. Kohli, learned senior counsel appearing for the respondents. These matters stands adjourned till 7th of April 2025. List accordingly. Yes.
Grateful, Lordship. Deeply obliged.
11, 12, or 14. Huh? Yes.
Not this covered matter.
Yes.
my lord. Lordship may dispose of law. Subject to what my friend in finance department is not there.
So petitioner is a former employee of
The court
Assam State-
is one of 4 laws.
Only one petitioner is not the employee, he is the wife of an employee.
One of the
Petitioner number 3, my lord. So only one line can be changed, my lord, in the order, my lord. That page,
There are 5 petitioners who have joined, is it?
yes,
We'll only say consider as per the order dated so and so.
Lordship.
No other direction can be given because
yes.
5 of them are
but
together.
one factually incorrect sentence is there, my lord.
Hmm.
Page number 105, paragraph number 3.
Page number 105.
Yes, my lord. Paragraph number 3, 2.
Mhm.
Petitioners are the erstwhile employees. In place of petitioners, my lord, petitioner 1, 2, 4, and 5. And
But
petitioner,
this is another order. This is an order passed by a coordinate bench. You want it to be corrected in this case?
no, I do not
Then-
want. But if actually it will be incorrect, my lord.
Whatever is there is there. Nothing can be done about it.
The operative portion is all right, my lord. That will do, my lord.
All right, take down heard Mr. P.K. Goswami, learned counsel appearing for the writ petitioners. Also heard Mr. N. Upadhyay, learned standing counsel Irrigation Department Assam, appearing for the respond numbers.
Lordship, three lordship, 4 and 5 are no longer this lordship.
Respond number 3,
One, my friend will appear.
Mr. Ardhar, learned additional senior government advocate Assam has appeared for respond number 1 and Miss
P Nayak for finance.
and Mr. P. Nayak, learned SC Finance for respond number 3. It is submitted at the bar that the respond numbers 4 and 5 are no longer in existence. Full stop. The petitioner's husband, the husband of the petitioner's hearing.
Number 3, my lord.
Achha, others are employees.
Other employees, number 3 lordship, mismatched lordship.
These are very bad petitions. They should be dismissed, but I will not because the petitioner numbers 1, 2, 4 and 5 are the former employees of the now defunct Assam State Minor Irrigation Development Corporation Limited, bracket ASMIDC, bracket close. And the petitioner number 3 is the widow of a former employee of the ASMIDC. Full stop. The grievance of the petitioners is to the effect that despite the directions issued by this court by judgment and order dated 13/5/2022 in WPC number 9562/2019, the VRS benefits including house rent, medical and city compensatory allowances have not been paid to the petitioners till date. As such,
VRS benefits has been paid, excluding this lordship. He is
VRS
now,
benefits pertaining to so and so, so and so, so and so, has not been paid to the petitioners till date. Full stop. Mr. Goswami further submits that the case of the petitioners is squarely covered by the judgment and order dated 13/5/2022 passed by this court. And therefore, the writ petition be disposed of accordingly. Full stop. Mr. Upadhyay, standing counsel for the irrigation department, submits that save and accept house rent, medical and city compensatory medical benefits and city compensatory allowances. All other benefits under the VRS scheme have already been given to the writ petitioners. The said assertion has not been contested by the learned counsel for the writ petitioners. Full stop. Now, before that, you write, Mr. Upadhyay has, however, fairly admitted that the case of the petitioners is covered by the judgment and order dated 13/5/2022. Full stop. The assertion made by Mr. Upadhyay has not been contested by Mr. Goswami. The above assertion contested by Mr. Goswami, learned counsel for the writ petitioners. Full stop. In WPC number 9562 of 2019, similarly situated petitioners had approached this court by raising similar grievance. Full stop. The said writ petition was disposed of by this court by order dated 13/5/2022, issuing the following directions. Page 107 of our double tick to double tick. Full stop. Since there is no wrangle at the bar that the case of the writ petitioners is also covered by the judgment and order dated 13/5/2022, this writ petition stands disposed of at the motion stage by providing that the case of the petitioners shall also be considered in terms of the directions issued by the learned single judge by judgment and order dated 13/5/2022 and within the timeline prescribed therein.
Master.
Item 2.
But I have received the instruction as directed by the Honorable Court.
Hmm.
The
Yes, what is the instruction?
instruction one is the petitioner, the given marks, but they are not above the cutoff marks. That's why, they are not appointed. Only 7% were found above cutoff mark, they were appointed after passing of this order. Also, kindly see serial number 38, bold letter, my lord. 38, Torun Bunia.
But the other point was whether they have been informed.
No, process is this has been done by the state level police selection board.
Hmm.
And they have selected it and their record sent to the home guard. And it is the home guard department, those who are getting the eligible for appointment, they are informed by the home guard. And those who are not getting eligible for the getting the job, they are not informed, I think. Now I can provide him this. This 38 Torun Bonia, he got 46. Cutoff mark was 43. Right side, my lord. And the second petitioner, saying number 39, Joy Kumar Roy. He was given 2 marks, but he got 42. The cutoff mark was 51. So he is not eligible.
Mr. Chamo?
Well, if I am allowed to go through it, my lord, because that record my learned senior friend is having, if I can,
No, he is
Access.
given this table.
pardon me.
The table has been given.
No, my lord will see page 10. That is why I have annexed another mark sheet of another person who is also OBC category, who is also an SPO. He has been appointed after getting qualification percentage of 36.33% and SPO marks 2, total marks obtained 14. So my mark is above this number, this cutoff mark. Cutoff mark cannot be 51.
Yes, Mr.
This
Chutia.
is obviously, I'm annexed document,
Which one?
102.
Then you file your affidavit.
Then I will file clear
Madam.
all these things, my lord.
My lord, it should be
Mr.
noticed.
A. Chamolani, counsel for the
1010.
petitioners, also heard Mr. T.C. Chutia, learned additional senior government advocate Assam, who submit some instructions obtained in terms of the order dated 3/3/2025 passed by this court,
SPO2.
that in terms of the judgment in order dated 10/5/2024 passed in WPC number 3861/2022, the authorities had revisited the process, and after reviewing the marks obtained by the different candidates, 7 of them were found to have scored more than the cutoff marks, and they were appointed. However, insofar as the writ petitioners are concerned, the total marks obtained by them were below the cutoff mark, and hence no order of appointment could be issued in their favor. Mr. Chutia also prays for some time to file an affidavit bringing those facts on record. In view of the above, issue notice of motion returnable in 6 weeks since Mr. T.C. Chutia, learned additional senior government advocate Assam, has appeared and accepted notice for all the respondents. No formal notice is required to be sent in. Please extra copy of the writ petition. Requisite numbers be furnished to the learned.
That we have already given.
Let him file the affidavit, then we'll see.
Can I type back this chart, my lord?
Yes, yes.
Bless man.
May please your lordship. My lord, we require some time to take the proper instruction, my lord. We have already sent for the instruction, my lord. We have some time, my lord. He is on protection, my lord. Interim has been given, so.
All right, heard Mr. M. A. Islam, learned counsel for the writ petitioner. Also heard Ms. A. Gayan, learned CGC, appearing for the respondents who seeks 2 weeks further
Yes,
time
sir.
to complete her instructions. In view of the player made by the learned CGC, this matter stands adjourned for 2 weeks. Interim order passed earlier to continue.
Pass.
My lord. All right.
Thank you, Worship. My lord, these are the home guard, my lord, the trained home guard of 2010, 15, my lord. Problem is that, my lord, from 2015 onwards, no advertisement has been made, my lord. Although in 2017,
Show me a law, a decision
my
where,
lord, admittedly, that is fact, my lord, but only a representation, if your lordship,
no, we can't create all this trouble. This is not within the domain of the High Court.
Yes, my lord.
Rate code. We can't do that. Hmm?
Otherwise, one fact is, my lord, that when 2017 advertise has been made, when only in this area, my lord, they didn't get any information that they can take part in it, my lord.
No, but that's not the subject matter of your writ petition.
Yes, I have also stated here, my,
2017, 18, now 5, 6 years back.
they got the information in
You Move your local MLA to raise this issue in the assembly.
already exhausted, my lord.
Then be satisfied with where you are. What do you want to do? Withdraw or I dismiss?
Withdraw it, liberty.
All right. Mr. A.Y. Chaudhary, learned counsel for the petitioner seeks leave of this court to withdraw this writ petition with liberty to avail appropriate legal remedy as may be permissible under the law. Ms. U. Sharma, learned G. Assam, is present on behalf of the respondent and does not have any objection to this statement. In view of the above, this writ petition is disposed of on withdrawal with liberty as prayed for.
Bless.
My lord, I will immediate prayer lordship to consider my appeal lordship because other similar analogous matter, page 118 of the coordinate bench lordship already was issued for consideration of the representation. There are several communications that there for their fixed wages as per.
Only notice will go at this stage. Heard Mr. K. Majumdar, learned counsel for the writ petitioners, peruse the averments made in the writ petition. The petitioners are seeking a writ of mandamus directing the petitioners who are working as casual employees, so workers under the Hailakandi development block and engaged prior to 01/09/2005 have approached this court by filing this writ petition, seeking a direction upon the respondents to extend the benefit of minimum of pay scale to them. As per the government notification dated 03/10/2019, issued by the respondent number 2. Mr. S. Datta, understanding counsel PNRD Assam, has prayed for some time to obtain instruction in the matter. NIM 66, since Mr. Datta has appeared and accepted notice for respondent numbers
1, 2, 5, and 6.
1, 2, 5, and 6. Mr. R. Dhar, addition senior government, P. Nayak for 3 and 4.
Yes.
Miss U. Sharma. Who is appearing? U. Sharma? You are appearing in this case?
I'll solve the.
U. Sharma
For
for 4 designation like finance service or notice is deemed to be complete in this case. Extra
Lordship,
copy
one
is
small
extended.
prayer lordship. Pendency of this case may not be barred to consider the representation lordship
Pendency of this writ petition shall
Annexure
not be a
22,
bar for the
Lordship.
authorities to
by the
consider
commissioner.
representation bracket annexure.
Annexure 22 lordship, representation of 1st February 2025.
Annexure dated 1/2025 submitted by the petitioners, if so advised.
Lordship, in the cause list, GA Assam's name may be reflected, Lordship.
What should be done?
GA Assam.
By reflecting the name of G. Assam in the cause list.
I'll serve the copy lordship to
Yes.
them.
May it please your lordship. My lord, this writ petition is pertaining to appointment on commissioner ground, my lord. My lord, the petitioner before lordship was recommended by the district level committee, my lord. And thereafter filed a writ petition, my lord, that was disposed of, my lord, in 2016. Saying that within 30 days, my lord, the consideration of the petitioner's claim may be considered.
No compassionate appointment can be made now.
My lord.
So you have the option to withdraw or I will pass an order.
Lordship may kindly see only one order, my lord.
Hmm.
That is, my lord, page number
Yes.
50, my lord, 50 only, my lord.
If there is already an order, file contempt. But no direction can be issued to appoint on compassionate grounds. You examine the legal issue because you will not know why I have dismissed it. On the prayer of Mr. Ali, learned counsel for the petitioner, this matter stands adjourned for a week. List again for motion after a week.
Only the name of
By reflecting the-
handloom may be shown in the cause list.
By reflecting the name of learned standing council, handloom and textile department in the cause list.
Hey, please, your lordship.
Yes.
My lord, here, my lord, statutory appeal was filed before the Commissioner Central Assam, my lord. And that was subsequently, my lord, heard.
Running from pillar to post, find out what has happened.
That's a fact.
Had Mr. M. H. Chaudhary, learned senior counsel appearing for the writ petitioner, peruse the averments made in the writ petition on the request of Mr. S. Datta, learned standing counsel, Revenue Department, Assam. This matter is directed to be listed again on 24th of March 2025. so as to enable him to obtain specific instructions in writing and appraise this court as to the status of the appeal filed by the petitioner. Two extra copies of the written petition be furnished.
May it please the Lordship, petitioner retired on 31/8/2024, Lordship, at NHA 8, Lordship, on superannuation as a superintending engineer, PWD, Lordship. Thereafter, his retiral benefits have not been paid, Lordship.
Will issue notice. Part Mr. H.R. Das, Learned Counsel appearing for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner has retired from service on attaining the age of superannuation with effect from, it is not, date is not there. When did she retire?
Lordship, 31/08/2024, Lordship, NHA 7, Lordship.
31/08/2024. Full stop. Prior to her retirement, the petitioner was placed under suspension by the order dated 12/3/2024. Full stop. The petitioner was not reinstated in service during her tenure in office. This has resulted in a situation where the pension of the petitioner has been withheld.
Lordship, petitioner was reinstated during, before his retirement, Lordship. And thereafter, the departmental proceeding was concluded one day prior to his retirement.
The petitioner was reinstated before her retirement, and the departmental proceeding was also drawn up against her, was also concluded. However, the grievance of the petitioner is that her pension has not been settled till today, although there is no justifiable ground for not doing so.
Lordship, he was being paid provisional pension till last month, Lordship, but now they have discontinued it, Lordship.
Mr. Das has further submitted, further submits that even the provisional pension being paid to the petitioner has been discontinued since the month of February 2025.
February.
So, Mr. Ardhar, Understanding Council, PWD Assam, prays for some time to obtain instruction in the matter. Issue notice of motion returnable on 7th of April 2025. Since Mr. Dhar has appeared and accepted notice for respondent numbers.
1, 2, 4 and 5.
Why not 3? 1, 2, 3 and 5, and Mr. C. Borua.
4.
Learned Standing Council, Office of AG Assam, for respondent number 4. Service of notice is deemed to be complete in this case. Extra copy of the writ petition requisite numbers be furnished to the Learned Standing Council so as to enable them to obtain instructions facilitating disposal of the writ petition at the stage of admission hearing. It is made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law, it's advised. Yes.
May it please the Lordship.
Yes.
This application is preferred against the continued suspension of the petitioner who was placed under suspension on 1/10/2023. Thereafter, Rocco's notice was issued to him and he duly replied.
So we have to issue notice.
Lordship may dispose of the writ petition because the representation is pending. Where the representation we decided because
No, the petitioner was suspended.
and he in fact notified the department on 24/12/2024 regarding his reinstatement.
Not,
That is what the representation states, Your Lordship.
no, not that, Lordship.
So-
The department was well aware and Choco's notice
You
was.
obtain your instruction, motion states, Ms. T. Shom, Learned Counsel for the petitioner, where is the amendments made in the writ petition? The petitioner herein was placed under suspension by order dated 01/10/2023 in view of his arrest in connection with ACB PS case number 73/2023. The petitioner was subsequently released on bail, whereafter he had submitted representation for revocation of the order of suspension and for his reinstatement in service. Reinstatement in service. However, since no action has been taken on the representation dated 24/12/2024 submitted by the petitioner, he has approached this court by filing this writ petition. Mr. D. Bora, learned government advocate Assam, prays for and is granted 10 days time to obtain written instruction. Preliminary written instruction responding to the allegations made by the writ petitioner. Two extra copies of the writ petition be used. It is made clear that pendency of this writ petition shall not be a bar for the authorities to dispose of the representation dated so and so submitted by the petitioner by a speaking order if so advised. Let it come, then we'll see.
May I please, Your Lordship? My lord, the petitioners were selected in the year 1998, but their appointment was given in the year 2008 and 14. Since the recruitment process was initiated prior to the pension rules 2005, my lord, they are entitled to get the whole pension.
So they were selected in 1998,
98, yes,
but they were not appointed.
not appointed.
So now you want an order that they should be appointed.
There is a division bench order also, my lord, because government has also decided that the recruitment process which has been started,
Now they were selected in what process?
normal process, regular, by
Where is the select list?
select list is that case, my lord. NHO 1 page 15. There's a selection board.
And this list is valid till today.
Now exhausted, my lord. Everybody has been appointed. All the selected candidate has been.
That's right. You want this select list to be operated.
The pension benefit I need. Pension benefit.
Pension benefit?
Yes, my lord. Because our recruitment process was initiated prior to the new pension rules.
Achha, they were appointed but belatedly.
Yes.
When were your clients appointed?
Yeah.
When were they appointed?
In 2008, my lord. I have annexed the appointment letter. Annexure 6. A.
All right, then you obtain instruction.
My lord, there is a.
Do you have anything to say?
Lordship, I will bring obtain instruction, Lordship.
Now the case already closed by the division bench, my lord.
All right. This is
Because
single
government has decided
Instruction is
that
required.
they will
Lordship.
extend the benefit, my lord.
But Mr. I. Rafiq, learned counsel appearing for the writ petitioners, there is the averments made in the writ petition. The petitioners were, the case of the petitioners is that they were selected for appointment as assistant teacher of ME school under Mankachar LA constituency way back in the year 1998. However, the order of appointments were issued after a delay of nearly 10 years. That is only in the year 2008.
8 and 14.
2008
and 14.
More than 10 years. First of, due to such delay in appointing the petitioners, they are now exposed to a situation where their pensionary claims may be declined by the authorities. Hence, this writ petition. Mr. Rafiq submits that similar matters have already been decided by the division bench, granting relief to division bench of this court, granting relief to similarly situated petitioners. Hence, this case be also disposed of accordingly. Ms.
S.
Kaur, and standing counsel for the Elementary Education Department, Assam prays for some time to obtain instruction. In view of the above, issue notice of motion returnable in 4 weeks. Since Ms. Kaur has
One and three,
Mr. D. Bora, learned G. Assam has appeared and accepted notice for respondent numbers 1 and 3, and Ms. No, not 1 and 4.
numbering.
1 and 3.
Who is not there?
Achha, 2 is gone. 2 is not there in his petition. Where is 2 gone? Huh? No 2.
Yes, there's a typing mistake. 1, 2, 3. Yes.
You are the counsel in the other matter also.
Yes,
Oh, then typing mistake will happen. It is not your fault, computer's fault. Hmm. What to do?
I may be allowed to correct it. my lord.
By hand? No, you can't do it. You have to, these things go into the CIS. Those zamana is gone. By hand, no. You have to file a cost title.
Yes, my lord.
Mr. Deval and the government advocate Assam appears notice on behalf of the
1 and 4.
state of Assam as well as the director, pension and public grievance cell, and Ms. Kumar has accepted notice on behalf of the district elementary education officer Dhubri. Service of notice is complete in this case. On the request of the petitioners council, 10 days time is granted for filing amended cost title, rectifying the defect in arraying the parties in the writ petition.
Oblige me.
Director for the right line. Here for the-
Arraying the respondents in the writ petition.
Mayor, please, Lordship. Lordship, matter is regarding non-payment of salary, Lordship. The petitioner was appointed on compassionate ground, Lordship. On 16th, he was appointed.
Yes, Karbi Anglong.
I may be allowed to take instruction, Lordship.
First you make the salary irregular, then stop it, then take down. Heard Mr. P. Boiragi, learned counsel for the petitioner also. There was the amendments made in the writ petition. The petitioner was originally appointed as a chowkidar on 16/3/2023 on compassionate ground. However, after paying salary for 6 months, the respondents have stopped his salary since the month of September 2023. Since the representations made by the petitioner had failed to evoke any response in the matter, he has been compelled to approach this court by filing the instant writ petition. Ms. S. Campbell, understanding counsel for the KAC authorities, prays for some time to obtain instruction in the matter. NOM 4 weeks. Since Ms. Campbell has appeared, report hobo.
Respondent number 2, 3, and
Mr. R. Dhar, standing counsel PWD, has appeared and accepted notice for respondent number 1. And Ms. Kemprai for respondent numbers
2, 3, and 5, Lordship.
Why 4 is also default? 2 to 5.
4 is
Additional chief engineer.
additional chief engineer PWD.
It is default.
Default.
4, 2 to 5. Service of notice is deemed to be complete in this case. Extra for this. Here extra.
Oblige, Lordship.
Item 16.
May I please, your lordship.
Yes.
My lord, the matter relating to the, my lord, quantum of family pension, my lord. The petitioner has been paid, my lord, the lower pension.
All right, notice goes. Yes, Mr. Otto will issue. Heard Mr. M. Islam, like counsel for the petitioner. The petitioner is recipient of family pension. The dispute raised in this petition is pertaining to the quantum of pension received by her. First of Mr. S. Daftar, understanding counsel PNID Department Assam, prays for some time to obtain inspection in the matter. NOM 6 weeks. Who is appearing for whom?
I'm for 1, 4, 6, and 7, my lord.
For 1, 4, 6, and 7. And then
Hearing for 2 and 5. Lordship.
Ms. U. Sharma, Learned G. Assam for 2 and 5. And Mr. P. Naik, Learned S.
8.
Finance for respondent number 3. Service of notice is complete in this case. Extra copies, etc.
And you oblige, your lordship.
Oblige.
Please, your lordship. Lordship, I was appointed in Oil India Limited as in the post of operator 1 HMB. White advertisement number so and so dated 28 August 2020. Your lordship, I was appointed on 13/8/2021 provisionally. Then lordship, I worked for 1 year sincerely. Then on 6th of September 2022, I received the termination letter, your lordship. The ground was that my HMB license was not 4-year-old, whereas the criteria mentioned in the advertisement was to be, the HMB license was to be 4 years old, Your Lordship. My license is annexed at page number 27, Your Lordship.
Yes.
Yes, it is true, Your Lordship, my license is not 4-year-old at the time of when I applied for the job. Your Lordship, I applied for the job through online mode, and at that time I didn't notice that the criteria. So I applied for the job and eventually I got the job, Your Lordship, and I worked sincerely. But now when 1 year is completed, I was terminated from the job. And I was also blacklisted from from applying in any kind of job in Oil India in near future, Your Lordship. Your Lordship, I'm the sole breadwinner.
Where is the order? Where is the order?
Beg your
Where
pardon?
is the order of blacklisting?
Blacklisting, Your Lordship, termination letter is on page number 22, Annexure C. And
The last line.
last line, Your Lordship, paragraph 4.0,
Yes. Page 22, last line.
20 last line.
So any show cause notice was given before this?
No,
My
no
instructions, I have not
instructions.
I have not the entire instructions, but the fact is, she had committed the fraud. I mean, the petitioner had committed a fraud in this matter. The requirement was a license of 4 years old. Now, what was given, what was projected was the license of the 4 years old. On verification during the probation period, it was found that the license is of 2019. The license for light motor vehicle is there from 13. But what was the requirement is heavy motor vehicle license. That was 2019. Now, having fraud been committed, now the policy of Oil India would be, since fraud was committed at the very threshold, this person has lost the trust, and therefore the blacklisting had followed the termination. So to that aspect, I have
Termination is in probation period is a case of discharge.
yes,
That we may agree.
yes,
But
Lordship.
blacklisting you can't do without hearing.
I have to take my instructions on that, Lordship. Only on that aspect I have to take my instructions.
Better withdraw this blacklisting part, otherwise.
Let me take my
Passing
instructions on that as to on what power this blacklisting was done by
No,
them.
whatever be your power, you can't blacklist without serving a notice on him.
Maybe a notice was, I do not have that information.
Notice was issued.
Not.
I do not have that information till now.
Say the entire order.
Suddenly I got the termination letter, Your Lordship, and I did not committed fraud, Your Lordship, as I
All right.
yes.
See. The facts on record cannot be changed.
Yes, Lordship.
She is also saying the license was less than 4 years.
No, today she is saying.
No,
in this
no,
court,
it's all right.
if her representation will be produced, therein it has been stated that my license was 2013. I have not made a false statement.
All right.
Overall
But even then, if you want to blacklist, then you have to hear his version.
Lordship will fix the matter after 3-4 days. I'll take the instructions whether there is a notice issue or not. Otherwise, I'll instruct my clients itself to do something about it, Lordship. I'll take
Take
that.
it out because we won't have any option.
Yes,
So we have to proceed legally.
I understand, Lordship.
We'll go by law. And then if no notice or
I
prior
understand,
hearing
I
was done,
understand,
then
Lordship.
we'll stay the whole thing. Then
I
it will be
understand.
unnecessarily problematic for you.
Yes,
You
Lordship.
better withdraw the blacklisting. Your name, please?
S.J. Hayat. S.J. Hayat.
So and so for the petitioner. Peruse the statements made in the writ petition. Mr. A. Sharma, Learned Standing Council, All India Limited.
Yes,
pays
Your
for
Lordship.
Time till
On 18th, if Lordship will have it.
19th? 19th?
19th. Yes, Lordship, on 19th.
19th of March 2025 to seek instruction and appraise this court as to whether any show cause notice was issued to the petitioner and whether he was heard before issuing the order of blacklisting, within court's blacklisting. 2 extra copies of writ petition be furnished to Mr. Sharma. This matter be posted for motion again on
Let it be on 18th, Lordship, because 19th I will be out of station. 18th, I'll get the instructions, Lordship.
18th.
Obliged.
Obliged.
I think 18.
Now, please, your lordship. Lordship, this matter is related to compassionate family pension. The petitioner is the beneficiary of compassionate family pension, and her husband died in the year 2019.
Lordship, pension is stopped by director accounts, not by
Who is appearing for director accounts?
respondent number.
Pension was originally sanctioned.
Yes.
Already sanctioned,
Then why was it stopped?
the stop by director accounts and treasuries.
Take down, heard Mr. Your name, please?
MJ Bharali.
MJ Varali, learned counsel for the writ petitioner. Peruse the averments made in the writ petition. The petitioner is the widow of a government servant who died in harness on 31/5/2019. As per the scheme in vogue, the petitioner was granted compassionate family pension. Full stop. However, the family pension was stopped by the authorities since the month of May 2023.
Lordship, May 2024.
24. Why have you written 23 then?
Yes.
Huh?
Inadvertently.
2024. The representation submitted by the petitioner ventilating her grievances in the matter has failed to evoke any response. Hence this writ petition.
Lordship,
Ms. S.
interim-
Sharma, yes, yes.
Interim may be considered.
Ms. S. Sharma, Learned Standing Council, Health Department submits that
1, 4, 7 and 8.
the the compassionate pension has been stopped by the Director of Accounts, and therefore the departmental authorities does not have any role to play in the matter. Mr. P. Nayak, Learned Standing Council, Finance Department, Assam, is directed to obtain instruction and appraise this court as to the reason why the compassionate family pension of the petitioner has been stopped. 2 extra copies of the writ petition be furnished to Mr. Nayak during the course of the day. Registered to list this case for motion again on 21st of March 2000.
May I please, your Lordship? Lordship, petitioners are entitled to the salary benefits with minimum pay scale, my lord, as per notification dated.
By
3
filing
ten
this writ petition, the petitioners who are working as casual employees are seeking the benefit of minimum of pay scale. Heard, Mr. Your name, please?
H.L. Ashwin.
Counsel for the petitioners. Issue notice returnable in 6 weeks. Mr. S. Doctor, Learned Standing Counsel for the PNRD Department, Assam, appears and accepts notice on behalf of respond numbers
1, 2, 4 and 5.
4 and 5, and Mr. P. Nayak, Learned Asset Finance for respond number 3. As such, service of notice is complete, extra copies, etc., etc.
Most obliged.
Lordship, at this stage, I am seeking just the issuance of notice. Here matter relates to conduct of a review DPC. And also I am challenging
You're
the
challenging the speaking order.
speaking order also. On the basis that is factually incorrect.
Where is the speaking order?
Lordship, page 45. Page 45. More importantly, page 46, the findings. I'm seeking relaxation of the rules. Para C. Therein I have stated. Para C2. Additionally, Sri Rammilan has stated that Sri Padam Kumar assumed charge of chief engineer on 17/7/2020. That is factually incorrect. As per the records available with this office, Sri Padam Kumar assumed the charge on 29/6/2020 and superannuated on from service on 30/6/2021. This particular person was granted this relaxation on this respect, your Lordship. I have annexed at page number 55, the date of assumption of office is mentioned in the office of Sri Padam Kumar, in which the petitioner was there, since he was the ADG, and the petitioner is right now posted in ADC Chandigarh. Now, at this page,
Relaxation for what?
relaxation in the qualifying service. Now, to be promoted to be eligible for promotion to the next post of chief engineer, minimum mandatory 2 years command experience is required.
Right.
And he had 1.5 years of experience. And in the meantime, he was arrested in one CBI case. Now he is falling short by the 6 months period. Now the OM, if I may take your Lordship to OM, page number 15.
No, you will take page number 15, 17 later on. What
Yes,
is the
Your
case?
That particular relaxation, it says that
This is a condition of recruitment.
It's a condition of requirement.
Condition of recruitment cannot be relaxed.
That's what the OM says. It can be. If the juniors have been promoted, the eligibility condition can be relaxed.
if he has completed, if the senior, that is the petitioner, if he has completed half of that qualifying service. That is what is stated here.
Okay.
And on that basis of this, on the basis of this particular 96 OM of the DOPT, this Padam Kumar was granted this relaxation. That is my contention, Your Lordship.
Lordship, so far as his submission is concerned, Lordship, I would like to counter that by filing an affidavit, but initially I would like to point out, Lordship, this particular gentleman is in Chandigarh. How he can file a writ petition here?
Your Lordship, liberty was granted to challenge this particular speaking order.
Speaking order is passed by the ministry.
Yes, Lord.
He can challenge it, but why here?
Everything arose here. When he was arrested here, he was just posted right now to Chandigarh. So after.
Why do you file your affidavit?
Lordship.
Let him file his affidavit. Heard Mr. D. Warren and counsel appearing for the writ petitioner. And peruse the averments made in the writ petition. The speaking order dated 21/10/2024, by means of which the representation dated 15/4/2024 submitted by the petitioner seeking relaxation of the qualifying period of service for consideration for promotion to the next higher rank of chief engineer has been assailed in this writ petition. I peruse the grounds stated in the writ petition. Mr. R.K.D. Chaudhary, learned DSJ, appearing for the respondents, has prayed for some time to obtain instruction and file affidavit in the matter. In view of the above, issue notice of motion returnable in 4 weeks. Since Mr. Dev Chaudhary has accepted notice for all the respondents, no formal notice is required to be sent in this case. You are also there.
He is for respondent to UPSC.
No much role in this.
The 1 and 3 to 6.
1, 3 and 4, I am appearing.
1, 3 and 4.
Yes.
For 2.
And what about the others?
There are 4 not.
Only 4. 1, 3 and 4. And Mr. Todi for respondent number 2. As such, service complete, extra copies, etc.
Oh, nice.
Obligation.
We please your lordship. My lord, in this writ petition and office memorandum that is 18/9/24 that has been put under challenge. In fact, my lord, this OM is under challenge in a series of cases, and those are fixed on, my lord, 18th of March. My only prayer would be, my lord, to tag the matter with those cases, my lord.
All right, heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. N. Sharma, learned counsel for the writ petitioner. Here is the averments made in the writ petition. The OM dated 18/9/2024, putting a restriction on this on the scheme of appointment on compassionate ground has been put under challenge in this writ petition on the ground stated therein. Mr. Chaudhary submits that similar writ petitions challenging the same OM are pending before this court, which are fixed on 18/3/2024. In view of the above, issue notice of motion returnable on 18/3/2024. Since Ms. M. Bhattacharya, learned additional senior government advocate Assam, has appeared and accepted notice on behalf of respondent numbers. Your phone?
Respondent number 4 and 5, Lordship.
4 and 5. Then
2 also, Lordship. 2, 4 and 5.
2, 4. Upar Device Datta, Standing Council Revenue for 1 and.
It's also there. Or personally, yes, Lordship. 1, 2, 4 and 5.
Achha, for 1,
2, 4 and 5.
2, 4 and 5, and Mr. S. Dattal, Understanding Council Revenue and Disaster Management Department. Correspondent number 3, service of notice is complete. In this case, extra copy of the writ petition or requisite in numbers be furnished to the learned department council within 3 days from today. Let these matters be listed along with the connected cases.
Lordship.
Supplementary list promotion.
Thank you, Lordship. My lord, on the last date, Lordship was asked to obtain some instruction from the petitioner. My lord, the petitioner here is in the state of uncertainty. I pray to accumulate some days to communicate to the Lordship the instruction which she is willing to place before. She is praying for retention of another 1 year in her group center due to her mother illness, mental disability. whereas here the respondent here transferring her in another location, my lord.
My lord, the only difficulty is that, my lord, the petitioner was a head constable and now is promoted to assistant ASI. Now already she has taken over the charge of ASI, my lord. So the already complied with the order, my lord.
No, my lord.
And the place where she is
Is there any
posted, my
stay order operating in this case?
no, my lord.
No, no.
What do you want?
My lord, I need some time.
How much time?
And 2 days.
2 days.
My lord. A day or two,
I thought you will ask for 3 days.
my lord.
Okay, 2 days time. On the prayer of Miss
Iwa Pangla.
Pangla, learned counsel for the petitioner. This matter stands passed for the day.
Item 53.
Please, Your Lordship. The petitioner has put on the challenge the order of termination from service. Since no inquiry was held while arriving at that
Termination
particular
from
order.
service
Yes.
without holding an inquiry.
Well, summary, the termination order starts at page 33. If I may
Yes.
take your lordship to page 34. The second para. Whereas the undersigned had ordered a summary inquiry on this and had entrusted the responsibilities to the circle officer, Kamalpur Revenue Circle, come. And then the last paragraph, my lord, dismissed from the post of Gaon Pradhan. Now, that itself says that the summary inquiry was held and the procedure has laid down under Rule 9 has not been followed.
So
Now-
what should have been followed? Rule 9.
My lord.
Is he a government servant?
He is a government servant, my lord.
Show me the document to show that. A Gaon Pradhan is a government servant.
My lord.
He enjoys a regular pay scale.
Yes.
Where is, show me something on that.
Well, the executive instructions.
Mr. Sarma Barua, what are you reading? So,
No,
is he a
basically-
government
No,
servant?
basically, he has written that he has been appointed by following a selection of.
That's not the question. Are Gaon Pradhans government servants? He's saying yes, he's saying no.
No, he's not a government, regular government employee. He getting remuneration and it's a civil post, lordship. On the basis of a
Examine and come back to the court.
otherwise, lordship, against this, sorry.
Well, I have preferred a statutory appeal also against this particular order. And that is currently pending.
No, no, Mr. Bordar, nothing. First, you have to tell us whether he's a government servant. If he's not a government servant, Rule 9 doesn't apply. Then you have to satisfy the court, then what is wrong with this procedure? You said Rule 9. Rule 9 will apply only if he's a government servant. Come up with instructions. On the request of Mr. P. Varadwaj, Learned Counsel for the petitioner, Mr. J. Hendrik, Standing Counsel, Revenue Department, as well as Mr. C.K.S. Barua, learned government advocate appearing for the state. This matter stands adjourned for a week so as to enable the learned counsel to examine and address this court on the question as to whether the writ petitioner, having been appointed, whether the post of Gaon Pradhan is a government servant within the meaning of Rule 9 of the Assam Service Discipline and Appeal Rules within bracket 1964.
Number.
Item 54.
54 to 57 are similar matters, perhaps.
May I please, Your Lordship?
What are these cases?
My lord, the petitioner before Your Lordship is a RPF constable. My lord. What happened, my lord, they have been found by the Standing Medical Board of Central Hospital, Maligaon, that they are not fit for the present category of job, but they have been found fit for category C1. What happened, my lord, he has undergone a surgery, leg surgery, and implant some plate in his right leg. Thereafter, Your Lordship, kindly see the impugn order. Annexure D. He has been posted as cook.
Yes, who's appearing? You are appearing in this case?
Lordship, I am 56 and 57. So
All are similar
of
matter.
them.
Then you obtain instruction on all of them, preliminary instruction.
Lordship.
How much time you need?
This is from the division. Yes, today morning also I have sought for instruction. So
We'll have
Monday.
it on 21st.
21st.
My lord, I have already been spared. In the meantime, my lord,
No, we'll see. If we can make out a case, we'll interfere, otherwise nothing.
Lordship.
Mr. I. Rafiq, Learned Counsel for the petitioners, same order of all this. On the request of Ms. B. Sharma, learned CGC appearing for the respondents.
Item number 54 and 55. CGC. On behalf of Mr. S. P. Chowdhury. 4 cases, I have 56, 57. I am 54 and 55.
54 and 55, then pass two, write two different orders. SP Chaudhary and Manu. These matters are directed to be listed again on 21/3/2025, so as to enable them to obtain preliminary instruction responding to the grievance expressed in the writ petition. One extra copy each of the writ petition be furnished to the learned departmental council. Give
Yes.
one extra copy. Yes.
All right.
Put it in two orders.
What is it? Lord.
An application filed by Lordship that respondents for alteration, vacation of the interim order passed by this honorable court. It's a very simple matter, Lordship. It's not to be made complicated otherwise. It's a matter.
It always happens.
Lordship.
It always happens. Nobody makes a complicated matter simple.
It
Then the whole thing will go. The art is in making a simple matter complicated. That's why everybody is present. So why are you surprised with that?
No, not that. You're correct. That's absolutely correct. So this is a matter under this Sexual Harassment and Women Workplace Act. Just come in 2013.
First of all, who is who to give little
I'm
information?
appealing for Lordship that Institute IIT Guwahati.
Okay,
And-
who was the petitioner? Why has he filed this case?
Yes, my lord. So far as the
Just-
petitioner
just
is concerned,
getting-
I am representing the petitioner.
Huh.
Here, what has happened is, my lord. Lord, you may kindly have a look at the.
No, don't open your file, close it. Why has the petitioner filed this case?
My lord, he is, because my lord, after twice, my lord, closing, my lord, a proceeding under, my lord, this harassment act, my lord. They now for the third time want to, my lord, open the same issue.
The allegation is against your client
Yes, my lord.
of sexual harassment. at
376,
workplace.
my lord, trial is going on, my lord.
Yes.
My lord, on that plea, my lord, twice, my lord, they tried to, my lord, open up the issue. And my lord, their decision, my lord, that I placed, my lord, in my affidavit, that they closed it. Now, without there being a power for review or revision, they are, for the third time, my lord, they want to open the same issue by a separate committee. The change of, my lord, opinion of, my lord, those committees. Twice, my lord.
That has been stayed by this court.
That has been stated in fact, in the interim order, it has been mentioned that twice, my lord.
All right, where is the interim order? Let us see.
Yes,
Just
in the
one minute.
IA, my lord, it has been annexed.
In the IA, it has been annexed.
Yes, ma'am.
Page number?
My page number 19.
Yes.
The relevant will be my lord, page 20.
Page number 19.
Yes.
Page
my lord.
20. Page 21, the last.
21, the last para.
Yes.
Having regard to the of projections made on behalf of the petitioners, they are in fact that the proceeding has been again initiated by the internal committee Suenchok, Guwahati after a lapse of about 4 years. It is provided that till the returnable date. The further proceeding initiated by the internal committee IIT Guwahati against the petitioner shall remain in abeyance.
1 minute. So 2014, once it was closed.
14 it was closed, then again in 18 it was closed.
Then 2018, the committee, the same committee, internal committee,
Yes,
complaints committee has observed that there is a criminal case pending and this issue was barred by limitation.
barred by limitation.
Now for the third time. it has
Third
been
time they
opened.
want to open it, my lord.
And who has filed the stay vacating application?
By the, my lord.
We filed it. The institute has filed it, Lordship.
So what is the urgency in the matter?
No,
Clear
urgency,
the writ petition?
no,
Yes,
Lordship,
my lord. It will have to be hard.
Lordship. Urgency is that, Lordship, that under section 4, Lordship, of this Act, 13 Act, Lordship, a committee, every institute has to have a committee,
These are not even the issues.
Lordship.
Nothing of this sort will be gone into.
Just that,
Only
Lordship.
question is, once the committee has closed it,
No, that is the erroneous step the committee has taken. I'll satisfy, Lordship.
take action against the members first.
No.
You first take action
It's a
against them.
statutory authority, Lordship, but the view was that, Lordship, that I'll just take the Lordship to that clear. They have never gone to the merit. The complaint which was lodged by the lady employee, that constituted alleged two offences. One is under 376, that is going on. Other is the continuous harassment going on, she was subject to continuous sexual harassment by the petitioner. That aspect of the matter was not taken into consideration. When the FIR was filed, they have taken immediately the case was registered under 376, that is going on. But that the same complaint constituted another offense which was created by this act, that she was subjected to sexual harassment for about more than 2 years. That aspect of the matter was not taken into consideration by the ICC at that time, but they have somehow ignored it. When they found matter was placed before them, every offense of sexual harassment must be placed before the ICC. When it is placed before them, they have found that the criminal court has already taken cognizance of the matter. The trial is going on. Trial was going on 376 issue, not the other issue. The first time committee said, they said, oh, the trial is going on now. We cannot interfere into that. Second time, as the national court it has come, they said, no, the trial is going on. We cannot interfere. Third time it has come, they said, we have already viewed that since the criminal court has taken over the matter, so we cannot interfere in this matter. But any offense under sexual harassment, under this act, has to be initiated first by the internal committee. They must inquire into it. Once they inquire into it, then they find something is wrong, then they will, if there is nothing in the complaint, they'll dismiss the complaint. If they find something substantial in the complaint, they will record it. Then it will be treated as a misconduct under disciplinary proceedings. Then so-called notice will be given, it will go. But
Okay,
here,
Mr. I've understood your case. I'm not vacating the stay order, but the problem is your writ petition, the writ petition itself will be allowed if these are the arguments. You cannot subject a person to same kind of scrutiny again and again and again.
no,
You have to file a writ petition to set aside that ICC report.
no, ICC said,
You can't say that, okay,
no,
you have closed it, now we'll again do it. That power is
no,
not
no,
there.
I'll show the order itself. The committee had never gone to that issue.
Maybe, that means it's a wrong order. You cannot ignore a wrong order. You have to follow it because it is your committee.
Then
If you want to disagree with that, you have to issue notice to him. Have you
that's
done
why
it?
you have, that's what we have constituted temporary special committee to determine whether this matter should go to the ICC for inquiring or not, because there is statutory authority. I'll just show your lordship that their orders, lordship. Annexer, page 93, lordship.
All right. So writ petition will be heard in June. That's the only order which will pass today. There is no urgent. And these matters are, you see, you're putting, see, we're not saying that anybody who is guilty of any harassment to a lady should be shielded. But it raises a question on the manner in which the IIT is functioning. Thrice you hold ICC and you exonerate this
No, no,
man.
this is ICC, it's a statutory body.
Yes,
It's a
then the
statutory
fourth
body.
time you want to again subject him, what is this? It will go on happening till you get the desired result.
No, lordship, kindly see that order passed by the ICC. ICC, we have no control over ICC. It's a body constituted under the act.
Challenge it, challenge that decision of the ICC.
That's
then
why
by
you have-
filing a writ petition.
You are not to challenge, you have, that's why you have held it that this is wrong. You have to inquire into the matter. ICC is the only authority who can inquire sexual harassments. No other authority.
Correct.
So that's why you have placed it before the ICC again.
So if the ICC's order is not favorable to you, you will go on referring.
No,
the
no,
matter
lordship,
again?
kindly see the ICC. I have never gone to the merit.
It's a wrong order of ICC. But can you say that we will not follow it because according to us it is wrong?
No, they have never gone into the matter. Lordship kindly, they have under wrong they have taken a wrong view of the matter. They said since that criminal court is inquiring the matter, criminal court was never inquiring the issue of sexual harassment. They were only the 376. The complaint lodged by the complainant.
The ICC also says this issue is barred by limitation.
No, it will not be. That's what they say. Wrong.
Oh, yeah, you can't decide it like this. If you want to disagree, then you have to first give him an opportunity to explain why. You can't unilaterally do it.
That's why you have given him notice to appear before the ICC is satisfied. We've given it. Lordship kindly see the order of the ICC, page 93. I'm reading it. They have taken a wrong view
There
of the
is so
matter.
much chaos and confusion with the authorities, then the petty public cannot be made to suffer for that. If it is a case of harassment, constitute a committee, subject him to an
The committee
inquiry
is
and take action in the matter. You do
Committee-
it thrice and fourth time you want to do it?
No, not. Just Lordship kindly peruse 1 second's time, Lordship.
Yes.
Page 93. First time it was placed before the ICC, 19/12/2014. Since the matter, the view taken by the ICC was that since the matter is under trial and sub judice in the competent court, the committee has decided not to take no action regarding the complaint. The complaint has got two parts. One is that 376, another is sexual harassment part. They have never gone to that part. They said since the court has taken over the matter, court had taken the charges frame only under 376. The criminal court had never gone to the other matter. The criminal court cannot go. It is a decision to be proceeded through the ICC. Criminal court never had gone to that sexual harassment part. They have gone only 376. The trial is going on. When the matter is placed before the ICC, every issue of sexual harassment must be placed before the ICC. When the matter is placed before ICC, ICC took a wrong view that since the criminal court has taken over the matter, so ICC cannot go into that. He said it is a complaint relating to sexual harassment of workers. The committee would like to recommend the welfare measure. This is a different question, Lordship. Since the matter is under trial, Lordship, only the 376 part, not the sexual harassment part. Next time in a review, it has come to the ICC, not a review, it comes automatically on 27/4/2015. ICC said that, resolved that the matter is sub judice, again the same issue. And it is beyond the jurisdiction of ICC. No, never. Because it's an issue of sexual harassment. Only ICC can inquire. They said since the matter is sub judice matter which one? The 376 one. ICC that sexual harassment is going on for years together. That aspect of never taken into consideration by the ICC. That is a matter they can only deal with it. Third time when the matter come, they said ICC cannot exercise its power beyond its jurisdiction. There is no inquiry held formally. That complaint that ICC received from the victim referred to the serious offense like rape, where such conduct amounts to a specific offense, like rape under IPC or other relevant law. ICC shall recommend for such instances. Now, third time also, they said that the complaint constitutes only one offense, that is rape. No, the complaint, Lordship will kindly analyze the complaints. It will show that one is the rape aspect is there, sexual harassment aspect is also there. But under this act, Lordship,
Yes.
ICC is the only authority who can inquire into it, and they will not penalize it. If they say if they find something substantial, if they said they will say recommend this is a misconduct, and as a misconduct, the department proceedings will go. If misconduct is held to be misconduct, so-called notice will be given.
You're right.
No.
But you got that opportunity twice, thrice.
No, we did not get it.
The committee, you referred it to the committee.
Committee is already every institute must have a
Your
committee.
committee has not acted as per your ballot.
Therefore,
what can be
Lordship,
done?
therefore, last time what we have done, whether this should be tried, inquired by the ICC or not, to decide that with special committees appointed to examine whether the committee says, no, this is an offense entirely under this particular act, sexual harassment. The committee also, ICC also has to inquire about it. And then this time I has understood the problem, their difficulties or their erodes, Lordship, they have issued a notice. That's being challenged. The inquiry, in fact,
Mr. Kakuti, it could be a case of serious lapses by the IIT also. These are allegations of sexual harassment are very serious. It's a very shabby manner in which the whole thing has been dealt with.
We are helpless
So
because
19 June, writ petition will be heard. If you want a very detailed order, it might prejudice your. I can write, dictate a detailed judgment of 8-10 pages, but then it will have a bearing on the outcome of the writ petition.
it may be earlier, Lordship, because
Before 19 is not possible. There are other matters.
or alternately, let the inquiry continue, will not publish the results.
No, I'm dismissing this IA has been dismissed. Do you want a very detailed order or a very short order?
Ultimately, it will be the same. Lordship wants to decide to hear the whole writ petition, then in case.
Then you don't press this. If you press it then and don't succeed, then you can't say that I want it next week, next
No,
month.
but
That you can't say.
not to press it, the department is very serious.
Correct. Then let me pass an order.
Lordship will do that.
The main writ petition will be heard.
Lordship.
And the issues are whether you can at all do it. That is the first issue the court has to answer. Once you have constituted a committee, subjected him to that for right or wrong reason, the committee has opined that it cannot do anything in this case. It has been done thrice. Can you go on doing it as many times as you want? There must be some sanctity to the process. That is the first question the court will decide. Second question, if the answer goes against you, the court will find out who is responsible for this shabby exercise. We are not sympathizing with the petitioner. But that doesn't mean an exercise which is shabby will be recognized by the court. That can't be, because it will have a bearing on others. That's the point here. It's what you are arguing is not at all the point. It is not even the fourth or fifth point. Whether he has done something wrong or not will come much later. You got the opportunity, you subjected him to a internal committee's scrutiny, which is statutory. Then the committee says, sorry, we will not proceed. And let's do it thrice. And then fourth time you will say that, okay, now we'll have another committee. It will not happen like that.
Not the same committee,
The
not
law
not
can't
another,
be like that.
it's the
Law
same
can't-
ICC, Lordship. Members may
We have
define it.
missed the bus. So what can be done is for the next time, we can lay down some guidance. This time tentatively, you have missed the bus. You can't do it like this. You should have been careful in the first place also. You should have been careful when you referred the matter to the ICC on the first occasion. Now you have taken rearguard action. Now you are confident that this committee will find some fault with him. Why didn't you do it in the last 3 occasions? These are questions you will have to answer. And today, if we go into these issues and findings are recorded, then it will be prejudicial to your client. That's why I'm saying, what do you want?
Necessary order in that case. So we ultimately, writ petition has to be heard. as well.
Mr. Kavadi, we understand your client's anxiety, but they also have to understand that legal process is legal process. It doesn't matter who they are, what they understand, what they don't understand, doesn't matter. When the matters come to court, we have only one standard. And that standard only will be followed. That's the only standard by which even people are acquitted of heinous crime. That's the only standard. We are not bothered about whether IIT understands law or not. We don't expect them to, but there are mechanisms to find out. They have a panel of good lawyers like you. They should have consulted you earlier. I'm dictating the order here. Heard Mr. R.P. Kakati, Learned Senior Counsel, assisted by Mr. A.V. Dey, Learned Counsel appearing for the applicant. This will be in the IA. Also heard Mr. B. Gogoi, Learned Counsel appearing for the lead petitioner of this party. By filing this IA, a prayer has been made to vacate the interim order dated
19/9. 22.
19/9/2022 passed by the Learned Single Judge in WPC number 5959 of 2022. Restraining the respondents from proceeding further with the internal committee proceedings drawn against the writ petitioner. Mr. Kakoti, Learned Senior Counsel for the applicant, has argued that the 3 other earlier internal committees have wrongly closed the matter on an erroneous understanding and appreciation of facts as well as law, full stop. Since it is since the allegation is of sexual harassment, which is of serious nature, and the authorities of the IIT Guwahati have a statutory duty to have a proper inquiry conducted to such allegation, the interim order be vacated and the internal committee constituted for the fourth time be permitted to proceed with the matter in accordance with law. Full stop. The said prayer, has however, been stoutly resisted by Mr. Gogoi, learned counsel for the writ petitioner, submitting that his client cannot be repeatedly subjected to inquiry by the internal committee without any valid reason. According to Mr. Gogoi, once the internal committee has decided not to proceed with the matter, the question of subjecting the petitioner again to internal committee inquiry would not arise within the eyes of law. Full stop. After hearing the submissions made by learned counsel for both the sides, this court is of the opinion that serious question of law in the light of the arguments, in the light of the counter arguments made by the parties would arise for decision in the writ petition. And unless a finding is recorded by the court on those issues, it would not be permissible for the internal committee to proceed further in the matter. As such, the prayer made in this IA stands declined. However, considering the submission of Mr. Kakati, then as senior counsel, that there is some urgency in the matter, the writ petitioner will be posted for expeditious hearing. IA stands disposed of. In the writ petition, you write so-and-so for the petitioner, so-and-so assisted by Mr. Day appearing for the
Fixed
respondent.
that is given, Lordship.
Sorry?
Any fixed that is given, then it will be
Yes,
better.
19th of June.
Lordship.
Yes. On the request of senior counsel appearing for the respondent, this writ petition is directed to be listed on 19th of June 2025 as a fixed item. The matter will be taken up for disposal on the next date fixed. Parties to complete, pleadings are complete?
Complete, Lordship.
Parties to come prepared accordingly.
They will finally rejoin that.
Yes,
make-
rejoinder will file, my lord.
Then finally rejoin.
Parties to complete, parties to exchange pleadings accordingly. It is made clear that due to the urgency expressed in the matter by Mr. Kakati, and senior counsel for the respondents, no adjournment on the next date will be granted on the request of the petitioner's counsel. 19th, final, come prepared, will hear and
Interim will
decide.
continue, my lord.
Interim, in the IA, you write, interim order passed earlier to continue.
All right.
Obliged.
But you have understood the point.
I've understood.
This is a legal issue. It's a hurdle you'll have to overcome.
I understood, yes. That's,
And this is a question of law which the court has to decide.
that's it.
You can't go on like this.
Right.
Difficult case for your client.
Obliged.
You missed the bus. Yes, whom do you want to impeach, Mr. Sharma?
Yes, my lord, this is this person. This is regarding an examination of All India Assam Industrial Security Force. The person here has had secured 45.5%, whereas I have secured 47.5%, and he has been appointed, I have not been appointed. But
All right, I had Mr. R. Sharma, Lana Senior Counsel, listed by Mr. D. Lana Counsel appearing for the applicant. There is the statements made in the IA. The applicant is seeking impleadment of the sole respondent in this, of the opposite party in the connected writ petition as respond number 5. The grounds in support of the prayer have been stated in the IA. After perusal of the same, I am satisfied that a proper case for impleadment is made out. As such, the opposite party, namely Sri Jatin Rabha, is hereby impleaded as respond number 5 in the connected writ petition. Applicant to file amended cost title in the writ petition within 10 days from today. IA stands disposed of.
my lord, one more prayer, my lord. He may be served through Chairman Stateler, responding number
That
3.
will happen when the writ petition comes. Right now, only the IA has been disposed of.
Obliged, my lord. Obliged.
For admission, I can break it.
May I please, your lordship? Lordship, we are not pressing this matter, lordship.
All right, Mr. P. Majumdar, learned counsel for the petitioner, submits that he has instructions from his client not to press this writ petition. Ms. S. Kemprai, learned standing counsel KSC is present for the respondents. in view of the submission made by Mr. Majumdar, this writ petition is hereby disposed of as not pressed.
Obligable.
May it please, Your Lordship. The matter relates to recruitment to Central Police Organization. Now, way back in 2014, Lord, the petitioner was selected and he was appointed. Then, my lord, there was a judgment of the Delhi High Court where the Delhi High Court had said that those who get appointment based on reservation and all, their documents and all credentials should be verified. Now, my lord, following an exercise undertaken behind my back, a decision was taken that I am a person belonging to Manipur. And while applying, I have shown my domicile as the state of Manipur, but I have been appointed against the quota of Meghalaya. On that ground, my lord, a show cause notice was issued as to why my appointment should not be cancelled. At that stage, I approached this honorable court. There is a stay order operating. I am continuing. But fact of the matter is, my lord, the basis of this so cause notice is wrong for the simple reason, if your lordship would kindly come to page 59.
Pleadings are complete?
Yes, yes.
We'll fix it for hearing in June.
Yes.
Yes, heard Mr. K. N. Chaudhary and Senate Counsel assisted by Mr. Deori, learned counsel appearing for the writ petitioner. Also heard Mr. H. Gupta, learned CGC appearing for the respondents. It is submitted at the bar that this writ petition is ready as regards service and pleadings. Peruse the amendments made in the writ petition. Considering the nature of issues involved in the proceeding, the petition will require full-length hearing. Admit the writ petition since the parties are already represented. No further notice is called for. Register to list this case for final hearing as a fixed item on 24th of June 2025. Interim order passed. We have to continue.
One second. My lord, instead of 24th June, would your lordships either prepone it or, my lord, in July? My lord?
Okay, prepone it when 17th of June?
Yes.
17th of June.
Yes. Okay, my lord.
Yes.
Lordship, in this case, we have issued the PPO, Lordship.
The PTO has been issued. We'll close the matter. All right. You can keep a copy of this.
My lord. I have given him.
You given him. Okay. The issue involved in this writ petition pertains to non-payment of family pension to the writ petitioner, who is the unmarried daughter of the deceased government employee. First up, in terms of the order dated 3/3/2025 passed by this court, Mr. B. Chakravarti, learned counsel appearing for the respondent number 5, has obtained instruction and produced a copy of the PPO order dated 7/3/2025 to submit that.
Copy has been sent to her also.
With the issuance of the PPO, the grievance expressed in the writ petition stands redressed. Mr. K. R. Padgiri, learned counsel for the petitioner, on perusal, on examination of the order dated 7/3/2025 has 7/3/2025 issued by the senior accounts officer, Office of Principal Accountant General bracket ANE bracket close Assam, has agreed to the said submission. Mr. D. Bora, learned GA Assam, is present on behalf of the state. Taking note of the stand of the respective parties, this writ petition stands closed. A copy of the PPO dated 7/3/2025 be written in the case, record of this case.
Of like.
I'm appearing for 3 and 8. Acha, Mr. Nayak, 3 and 8. Okay. Timing is not possible today. You want to do it or another day?
Then, my lord,
On the prayer of petitioners council, this matter stands adjourned for a week. List accordingly. 1 week, yes.
May please, Your Lord.
Yes.
Timely, no, everything. Urgency.
May I please, Your Lord?
Here, my lord.
I pray for my senior is unlike Lordship.
Lord, I'm praying for passing some order here, although there is an interim order directing not to make recovery. Lord, what happened in this case, the petitioner, he initially joined in the year 1981. Thereafter, my lord, he retired and he retired on 2020, my lord. Then they have issued provisional PPO by which, my lord, I was granted 40,000 odd rupees as pension. That was released. And AG raised an objection that at the time of my initial appointment in the year 1981, I was given basic pay of 560 rupees. And as per them, it should have been 500 rupees. Now, pursuant to that decision, they initiated a recovery order. So all these orders issued by AG and recovery has been challenged before this honorable court. And this honorable court was pleased to pass an order not to make any recovery. During the pendency of the writ petition, what they have done, this on the basis of this 500 rupees, they have initiated a PPO order. And by virtue of that, the pension 40,000 odd rupees which I was getting, that has been reduced to 36,000, number one. Number two is that my instruction from this month, my department has not initiated the bill for release of the pension, so I'll not get pension this month. So today, my lord, I am neither here nor there. That is, so I want that, my lord, lordship may be pleased to pass an order directing the respondents to release the pension as per the previous provisional PPO order till the.
So where is the material? All that you have said are oral.
Yes, material is there, my lord. The change that they wanted to make. Lordship will kindly have. I'm sorry, my lord. I beg my apologies. Annexure 1.
No, during the pendency of the writ petition, they have issued a PPO by taking your original at 560. Is it?
500.
500.
The changed one.
Yes. Where are those materials? Have you brought it on record?
No.
Bring
Just
it and
now.
then we'll pass. Huh?
My lord, just few days back, I can break it, my lord. Yes.
Because without
I understand. I'll file an IA, my lord. I'll file an IA.
Yes.
That'll be better. My lord.
Pass an order.
Fine, my
All
lord.
right. Then what order should be passed here?
My lord will give me
On the request of
week's
Mr.
time, my lord.
Learned Counsel for the petitioner, this matter stands adjourned for a week. First, to enable him to file an interlocutory application, making a prayer for interim relief. Ms. U. Sharma, Lanet G. Assam, and Mr.
R. Boro,
R.
we have
Boro,
C. Boro, Lordship.
C. Burua, Lanet
For
Counsel
resolution number
for the
3 and 5, 3, 4 and 5.
Office of AG Assam, are present.
No, the interim order pass earlier may continue.
Interim order passed earlier. Yes.
Item 36.
None appears for the petitioner on call. Ms. Again, Lanet Counsel is present for the department. Since the petitioner's counsel is absent today, this matter stands adjourned for 3 weeks.
Master.
37.
May I please, your lordship? My lord, in this matter, the respondents were to file their affidavits, my lord. Till date, my lord, they have not filed their affidavit.
Yes, Lordship. My affidavit is pending, Lordship. Finance Department, Lordship. So I'm praying for some time, Lordship.
My lord.
The petitioner's counsel is present on the request of Mr. P. Nayak, Lanet Standing Counsel, Finance Department, Assam. 3 weeks further time is granted for filing affidavit.
Lordship.
Let the matter be listed accordingly.
Item 38.
The order of suspension was under challenge, my lord, in this court. And the last occasion, my lord, the records were called for, my lord, regarding a review committee. my lord.
Yes.
Lordship, here Miss M. Bhattacharjee is appearing in this matter, but records were called for, but we have not received the records yet, Lordship.
No, why records call for, where is Ms. Bhattacharjee? Please call her.
Lordship, it may be fixed.
No, we'll call her after 10 minutes.
Lordship.
Yes, call her.
What people then?
Wait, please, your lord.
My lord, the matter pertains to prolonged suspension.
Hmm.
Though DP has been initiated and review has been done, still, my lord, the departmental manual of the government provides that, my lord, suspension has to be kept to barest minimum, my lord. And the review orders, my lord, does not reflect any cause and ground for it. They simply say that the charges are grave, so you are
So petitioner was suspended when?
27/1/2024.
That is all 6-2, rule 6-2.
Rules,
Arrest.
yes, under rule 60.
Then what has happened? It has been reviewed.
Yes, it has been reviewed from time to time. Within time, my lord.
Now, what is the issue here, Mr. Patwari?
My lord, the departmental manual clause 2.14 says, my lord, that there are certain grounds on which suspension can be made. That is, if the government is of the opinion that there may be a tampering of evidence, influencing of witnesses. However, in all those cases, it says that the suspension has to be kept on barest minimum. And division bench of this honorable court is also held prolonged suspension takes the color of punishment, my lord. Now 1 year, 1 month, 2 months has already passed. Departmental proceeding also, my lord, is going. The petitioner is still kept under suspension, my lord, without any reason.
We have not received any instruction, Lordship. However, Lordship,
No, you will not receive instruction naturally. You are putting someone in suspension and then you don't have instruction.
just now we have received an communication that due to budget session, they have not prepared the instruction, Lordship. They could not do it. This is the communication just now that I received, Lordship. Other, Lordship, in the, and the other should be paragraph 22, Lordship, that it was says that since charge sheet was issued, court have not interpreted the suspension order. And following this paragraph 22, the Supreme Court, another case in 2022.
Listen. Those will come later.
Lordship.
The order that will be passed is by this court, not by Supreme Court or any other court. These are all relevant materials we'll consider. But that will happen only when the court proceeds to pass an order. Are you ready for the order today?
Lordship, I'm praying for 1 week time, Lordship.
1 week time.
Lordship.
What will happen in 1 week?
Lordship, I'm taking just on what is the stage of the DP.
No,
I've
what
taken.
stage? We'll dispose of the writ petition finally.
Lordship, that may be that can be
Either
done,
he is
Lordship.
entitled to relief or he is not entitled to relief. It's a pure and simple legal issue.
And Lordship may direct the
If you
DP.
don't
may-
want to file affidavit, it's your prerogative.
Lordship may direct the respondent authority to conclude the DP within the time frame, within a month or within. Since that has been,
My lord, I am here for revocation of suspension. DP is going on, my lord, since last 1
He's
week.
not bothered. You take another 3 years in the DP. He is not unhappy.
That is what kindly bear with this clause 2.1.4, my lord. Their departmental manual.
You read it first. You show it to him.
2.1.4.
Yes.
Although suspension is not a punishment by itself, it cannot be denied at the same time that in such cases, the officers placed under suspension suffer a lot. Apart from this, suspension of a government servant is a liability on the part of the government. The idea behind placing an under suspension is not to inflict punishment, which can be done only when the charges are proved, but to safeguard against further loss to the government, manipulation of records, intimidation of witness, or embarrassment to the government in the public eye, as in the case when moral turpitude is involved. In all cases, suspension, the elementary justice demands that period of suspension should be reduced to barest minimum. It is therefore necessary to conclude proceedings drawn up as quickly as possible, and in any case, it is not possible to do so due to reasons beyond the control. The persons proceed against may allowed to resume their duties where possible in place away from their former place of duty, vacating the suspension order so as to save government expenditure in the event of acquittal.
When are you going to be ready to finally disposal of this matter?
So after 1 week, I can.
After?
1 week, Lordship.
Give him 1 week.
Yes.
J. Patwari, Learned Counsel, have appeared for the writ petition. Mr. S. Datta, Learned Standing Counsel, Revenue Department, Assam, submits that due to the ongoing budget session, the requisite instruction could not be furnished to him by the departmental officials. Mr. Doctor, I was 6 posting of this matter again on 23/2025. So as to give him one more opportunity to obtain instruction. Ms. M. Bhattacharya, learned additional senior government advocate Assam is present on behalf of the state. On the request of learned counsel for the respondents, this writ petition is directed to be listed again on B-16/2025 as a fixed item. These some other matter, call it after this.
Your Lordship, other side was about to file their affidavit. Lordship, we are
Reply.
yet to get the instruction. Lordship, may give me short time, 3 weeks time, Lordship.
Instruction from whom?
From the respondent, Lordship. Authority, Lordship. We are yet to file our affidavit response to the petition. 6 weeks time was already been given.
Some departmental proceeding is going on.
Now, Lordship terminated to a dismissal, Lordship. That has been challenged. Appellate order is also there. That has been put to challenge, Lordship.
So you file your affidavit, you can't delay this matter.
Lordship.
How much time? Make a last,
Let
request.
it be 4 weeks, Lordship.
last chance, 4 weeks.
3 weeks.
Heard Ms. S.B. Borua, TG, learned counsel appearing for the petitioner. Also heard Mr. B. Chakravarti, learned CGC, who submits that instructions as called for are still awaited. Therefore, further 4 weeks is prayed for the purpose of obtaining instruction and filing affidavit. Prayer allowed as last chance. Let this matter be listed again after the upcoming BU vacation. In the meantime, affidavit on behalf of the respondents be brought on.
Deeply.
Pending matter item 38.
Lordship, in item 38, as per last order, Lordship, record was to be produced, Lordship, but we have not received it. I'm just praying for a week time, Lordship, so that I can get it.
It was placed under suspension, my lord. In connection with a criminal case. Where we
20th,
22,
20th,
Lordship, 20, Lordship.
Yes,
Yes,
but
Lordship.
then don't compel us to pass a.
No, Lordship,
Please
that's
tell
why
it.
I'm just praying,
We
Lordship.
are requesting you. We'll, next time it's
Lordship,
personal
Lordship, I
appearance.
shall.
And we'll record everything so that
Lordship,
people know what is happening. 20th,
20th.
20, Lordship.
heard Mr. P. Kotakil on a counsel appearing for the petitioner on the request of Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing for the state. This writ petition is directed to be posted again on 20/03/2025 for admission as a fixed item, so as to give her one more opportunity to produce the records.
Obliged, your Lordship.
Supplementary list for admission item 58.
None appears for the writ petitioner on call. Matter stands adjourned. Mr. D.P. Vora, learned standing counsel,
Health and Family.
Health and Family Welfare Department, Assam is present. Since the petitioner's counsel is absent today, this matter stands adjourned for 4 weeks.
For order, item 41, 42, and Please, Your Lordship. My lord, here in item number 41, we are representing all the private respondents, my lord. Here, respondent number 3 has already filed his affidavit in opposition, and remaining private respondents will file our affidavit in opposition by course of the day, my lord.
And who is appearing for the petitioners? None has appeared for the writ petitioners.
My lord, in item number 42, we have the petitioners, my lord, 42 and 43. So, my lord, in 42, you have verbally instructed by the petitioners to represent them, but the NOC is yet to be received from the earlier sets of council, my lord.
So none appears for the writ petitioners in item 41. You put the case number. I'm saying item 41, when you put the case number.
My lord, and item number 43.
1 minute, your name please?
A Devi, my lord.
A?
A Devi.
Miss A. Devi, learned counsel appearing for the writ petitioners in item 42, submits that she has oral instructions to appear for the petitioners in item 43 as well.
Yes.
However, due to want of NOC, Wakalatnama is yet to be furnished to her.
My lord, in item number 43, we are already for the petitioners, but all the respondents are being represented, but the affidavit is yet to be filed by them.
In item 43, you are for the petitioner and the respondent both.
No, only
Then-
for the petitioners, my lord.
So where you want NOCs?
42, in item number 42, my lord.
So the 42 and 43 interchangeable. 43, she is already appearing, and 42 has oral instructions to appear. But Wakalatnama has not been filed due to want of NOC from the previous council.
Yes.
Ms. Devi, who is appearing for the private respondents in item 41, has prayed for 4 weeks' time to file affidavit. Mr. D. Gogoi, learned Standing Council. for
PhD, madam.
PhD Department, Assam, and Ms. P. Sharma.
I have
Understanding,
42, lord.
Understanding Council appearing for the APSC
APSC respondent number 2.
are present for their respective clients. On the request of learned counsel for the parties, let these matters be listed again after the upcoming Bihu vacation.
My lord, there is an interim order in item number 43.
Interim order passed in item 43. Just check it once. Shall continue until further
My
orders.
lord, one more prayer. There is a similarly situated case number WPC number 5693 of 2023, my lord. It may be tagged, my lord.
5693 of 2023.
23, my lord.
On the prayer of learned counsel for the writ petitioners in item 43, let these matters be listed along with WPC number 5693 of 2023, which is stated to be analogous to the present proceeding.
Much obliged. Item 44.
Also contempt to petition lordship, we have taken steps as per order passed by this honorable.
You're appearing
Sir,
for
I
the-
respond number 2, my lord, sir. I
Yes.
appear on behalf of Dinar. We are going to file affidavit, my lord, sir.
Who's the respond number 2 here? I find only respond number 1.
To lordship, we have submitted amended course title also. Lordship.
There is no respond number 2 here. Acha. And what about respond number 1?
Respondent number 1, lordship, transferred.
Earlier there was sole respondent.
Lordship. And
All right, you take down heard Mr. L.R. Majumdar, learned counsel for the petitioner, also heard Miss,
And Barman on behalf of Dinat, my lord, sir.
whose name should I record?
Dinat, my lord, sir.
Also heard Mr. D. Nath, learned counsel appearing for the newly implemented respond number 2, who prays for and is granted 2 weeks' time to file affidavit. Let the matter be listed accordingly.
Obvious, my
all
lord.
right.
Item 45.
Hello, this is a restoration petition, my lord. It is, it was dismissed for default for non-prosecution on 2/5/2024, my lord.
Yes. You are appearing.
Yes, sir.
It is already over.
Any objection?
Delay has already been condoned, lordship. Delay was there, 20 days delay, it has already been condoned. So
It is condemned by disposal.
this matter may come up for hearing because it was.
I take down, I heard Mr. P. Mohanto, learned counsel appearing for the applicant. Also heard Mr. S.P. Chaudhary, learned counsel representing the opposite parties. This miscellaneous case has been filed with a prayer to set aside the order dated 2/5/2024, passed in WPC number 3239/2014, dismissing the writ petition for non-persecution and for restoration of the same in its original record. I have perused the grounds stated in the petition explaining the default on the part of the petitioners.
456.
Also heard the submissions made by Mr. Mohanto in support of above grounds. Full stop. Mr. Chaudhary, Lanet CGC submits that he does not have any instruction to file objection.
Not required, Lordship,
Huh?
because it's otherwise not required, because the thing is that since the delay has already been condoned,
Hmm.
this matter may come up for hearing. This is my submission.
Before restoration,
No, I'm not on that, since
we are now
the
considering the
restoration, I have no objection. But with
You
regard to,
have not filed any, you don't have any, have you been instructed to file objection?
no, I have no,
Then why are you opposing the courts dictating the order? Submits that he does not have any instruction to file objection opposing the prayer made in the miscellaneous case. In view of the above and considering the explanation furnished by the learned counsel for the applicant, the prayer stands allowed. The order dated 2/5/2024 is hereby set aside. The writ petition being WPC number 3239/2014 is stands restored to its original file. Miss case stands disposed of. No, before that, you add one line, office to list the writ petition after 2 weeks for necessary orders as a fixed item. Miss case stands disposed of. And that day you get a, you don't listen to the court's order.
no, Lordship, I'm not on that. No, what I'm saying, the instruction,
misunderstood.
instruction with regard to that, that's some
No,
difficult.
you have instruction to
No,
file
Lordship, there is
objection.
no instruction.
Then
There is no instruction.
it has to be either you have instruction, you didn't file, or you did not have instruction. We have to dictate our order.
All right, Lordship, I'm sorry about
Must
that.
not be done.
May I please, Your Lordship? It's a matter regarding the reimbursement of medical bill, Lordship.
Matter is not reimbursement of medical bill. Matter is violation of, alleged violation of the court's order. Has notice been served?
Already served. Lordship.
Served. How many petitioners
Only one, Lordship.
and respondent?
Respondent, sole respondent, director. Medical. line. What are relevant page 10, Lordship?
So some new respondent has been impleted. You have not filed amended cost
Already
title.
I filed, Lordship.
Huh?
I pleaded, Lordship. Second file. Lordship.
You have filed amended cost title.
Lordship.
When? When did you file amended cost title?
It is
Mr.
already
H. Alamgir
in
Learned
Second
Counsel.
file, Lordship.
Huh?
It is also in file, Lordship. I see.
Have you filed amended cost title?
Lordship, Lordship.
You filed.
Filed.
When?
It is
Do you know the meaning of amended cost title?
Lordship, Lordship. It is
When did you file it? Let me see.
file number 2.
Where is the amended cost title? No, I heard Mr. H. Alamgir Learned Counsel for the petitioner, Peru's office note dated
File.
19/12/2025, which goes to show that the petitioner has not yet filed amended cost
Filed.
title.
Substitute his
In
name.
view of the
only.
above,
He was no longer, that's why I am.
let this matter be listed again after the amended cost title is brought on record. You don't even know what is the meaning of amended cost title. You are referring to implement application. Amended cost title is you have to bring a new cost title so that the data is entered in the system.
Direction is amended.
Okay, fine. You go and ask somebody else.
made to the lordship. So in this case, the office note shows that the service upon response are not complete.
So-
AD card has not also received, not received and.
You are
unchecked.
Lordship, I'm appearing for all. For one, I have already filed my affidavit. So, Lordship, may I kindly take your Lordship to page 21. Here, Lordship, while disposing of the writ petition on the very first day, because similar matters were disposed of, Lordship directed the last paragraph, Lordship, page 21. So accordingly, we have considered his case. Staff Selection Commission has considered his case, Lordship, and we found that although in the writ petition it is stated that he had scored more marks than the last unreserved category candidate, but the marks he obtained, that is for more than the border categories, but he belongs to general category, so his marks is less than the unreserved category candidate, so he cannot be given.
So have you issued him that letter? You have
Yes,
to
yes,
come-
we have intimated my.
Intimated.
And
Where is that copy?
that affidavit of respondent number 1, I have stated, Lordship, that we have already given it to him.
No, where is that letter? You have
Yes,
already
20.
issued a letter, right?
Yes, yes.
To him.
Yes, Lordship.
Where is the copy of that?
Copy, Lordship, that copy is not, but the order copy is here, but issuance letter is not with me, Lordship. That we have intimated him, that letter is not with me, but we have intimated him.
Page 25, lordship.
You have received
Yes,
intimation.
which is, I have annexed it to the petition.
Page
25.
You have to file challenge this in a writ petition. Contempt is over.
His marks is less. So that way he is not eligible. We have considered his case.
So the court has said subject to fulfillment of eligibility. Then you have challenged this order, but Mr. R. Sharma, learned counsel appearing for the petitioner. Also heard Ms. B. Sharma, learned counsel representing the respondents who submit that by the order dated 20, what is the date?
5/2/2024. This is the order of this honorable court.
No, their order,
Their order 25/2024.
25,
20/2025.
2024. The petitioner has been implemented by 25/2024. The case of the petitioner was considered as per the order of this court, and the same was rejected due to the reasons cited therein. If that be so, the remedy would lie for the petitioner in assailing the order dated 25/2024. Thus, granting liberty to the petitioner to pursue appropriate legal remedy if so advised. This contempt case stands closed.
Okay.
How many more matters?
My lord, I am appealing for respondent number 2, 4, and 5, my lord. And I have not received the copy, my lord, of the.
Copy we have already served, but.
Not to me.
Okay, and who is appearing for other respondents? 1, 3, and
Service completed.
I'm on behalf of SKMT, he is for number 3.
okay, service complete. Let it be listed for admission.
Yes, my lord.
All right.
And one prayer is interim prayer provisional pension, my lord. 21, he is retired on 37/2021.
We'll consider it on
Yes.
the. Heard
Date
Mr.
may be-
A. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Bhattacharjee, learned additional senior government advocate Assam, appearing for the respond numbers.
One lordship.
Respond number 1, Mr. S.P. Das.
For 2, 4, and 5, my lord.
And counsel for respond numbers 2, 4, and 5. And Mr. S.K. Medhi, learned counsel for respond number 3. In view of the above, this matter is ready as regards service. office to therefore, list this case for admission hearing after 10 days. On the next date fixed, the prayer for interim relief made by the petitioner's counsel will be considered. Parties to come prepared accordingly.
Obliged.
Will we be allowed to file the affidavit, my lord?
No permission is required to file affidavit. Is there any bar?
No, man.
Then you file it.
I have filed the IA lordship for extension of 4 weeks time to comply with the order lordship passed in 5/11/2024 lordship in WPC number 2106 of 23. Details I have stated in para 3, page 4 of my IA.
Yes. 60 days, how much time you want extension?
4 weeks only.
4 weeks with effect from?
From today, lordship.
Yes.
I leave the lordship.
All right, heard Mr. M. Nath Lanet. No, you're right. Heard Ms. D. Bora Lanet, Standing Council Health Department, Assam, appearing for the applicant. Also heard Mr. M. Nath Lanet, Senior Counsel, appearing for the opposite party number 1. Mr. D. Bhattacharya, Lanet Counsel, is present for the opposite party number 2. Full stop. This application has been filed with a prayer seeking 4 weeks further time to comply with the order dated 5/11/2024 passed by this court in WPC number 2106/2023. I have perused the statements made in the application. Stop. Mr. Nath Lanet, Senior Counsel for the OP number 1, submits that he would have no objection if further 4 weeks time is granted to the department, provided no further extension of time is sought for implementation of the court's order. Ms. Bora, Learned Counsel for the applicants, have assured this court that if 4 weeks time is granted with effect from today for complying with the court's order, no further extension of time will be prayed for. In view of the above and taking note of the statements made in the application, 4 weeks further time with effect from today is granted to the departmental authorities so as to comply with the order dated 5/11/2024 passed in WPC number 2106/2023. IS stands disposed of accordingly.
Lordship, in this case, we filed a IA for amendment of the prayer, Your Lordship, of WPC number 1056 of 21. What had happened in Lordship is during the pendency of the writ petition, the petitioner had got promoted. We had originally filed a writ petition seeking promotion because the petitioner, instead of petitioner getting promoted, his junior got promoted, Lordship. So during the pendency, he has got promoted. But he has not been entitled to the conjugal benefit, Your Lordship, because the effective date of promotion was later, Your Lordship, and which ought to be on 2020, Your Lordship. 3 years gap is there, Lordship. So now we have filed this application for amendment of prayer for the conjugal benefits, Your Lordship.
But where is the pleading in the writ petition? Where is the pleading in the writ petition for consequential benefit?
Lordship, at that time he was not promoted, Lordship.
Then you have to amend your pleadings also. Only prayer will not do. Only prayer will not do. Where is the pleading? They have to file their response. You better withdraw this and file a new writ petition.
Lordship, in my limited knowledge, the pleadings were at that time were we had
All right,
filed-
but now the situation has changed.
Yes, Lordship.
You are only changing the prayer, not the pleadings.
Lordship, may kindly take up the IA and
All right, then I'm dismissing the IA. It can't be done. You want to change the prayer without the pleadings in the writ petition? How are they going to respond to your pleadings?
Lordship, that I have to check once, Your Lordship.
All right, on the prayer of Mr. Jaydas, Learned Counsel, this matter stands adjourned for 2 weeks so as to enable him to obtain updated instruction. Mr. D. Upamanyu, Learned Standing Counsel, Health Department, Assam, and Mr. S. Datta,
For respondent 3.
Learned Counsel for the respondent number 3 are present.
Obliged.
Find the-
Obliged, Lordship.
Over.